welcome to our office hours. This is the second in our series we have now this year. This is probably the most widely known public initiative we have from the Europeana Copyright Steering Group. There's a few members of our steering group in the call, actually, and a few of us will also speak. We have a wide range of activities. We have a lot of public domain lobby work going on. We're doing work. We have some task forces on copyright related issues, but so we also have these copyright office hours. This time we have as a format, a general theme. The idea is to give a few presentations and then open the floor to questions that can be on the presentations or that can even be from your own perspective, questions you have, cases you want to bring forward, which we can then discuss later. As you saw, the presentation part is recorded, but only the presentation part. The discussion afterwards is not recorded because we really want this to be an informal discussion where there are no stupid questions. Everybody can chip in. We want this to be as informal and accessible as possible. Also, please don't hesitate to ask questions through the chat. And the idea is afterwards to publish the recordings with a small resume of what we discussed as a blog post or something. So today, in order of appearance, we will have first Ariadna, who will give a very general introduction on the topic that we are discussing today, which is licensing and labeling, rights labeling of works of art. She has a more broader perspective because she's from Europeana itself. So she will introduce the topic. Next, I will present a very concrete case where we have reviewed our rights labeling policy for a project we have in my organization, and that is called Art in Flanders. So it's a website with artworks of museums in Flanders. This is an ongoing project, very specific case. And then we are very happy to have Connor Benedict from Creative Commons among us, who will talk and explain about some initiatives and work that is being done around attribution through work groups and from the side of Creative Commons. So Europeana specific case, Creative Commons, I think this will be broad enough to lead to some nice discussions afterward.
So yeah, I can start with this. I'm going to do a kind of very general introduction to the use of standardized rights information, at least in the context of Europeana, which is organized through what we call the Europeana licensing framework. By standardized rights information, I mean expressing reuse conditions, especially when it comes to copyright reuse conditions, in a way that relies on tools that are standardized and easy to understand, in comparison with the alternative, which would be expressing it through more lengthy terms and conditions. So at Europeana, we rely very strongly on expressing reuse conditions through a standardized way. Here you see an example where we use the Creative Commons CC BY license. Because we work in a context where we aggregate content from many different countries, many different institutions, and the alternative to expressing reuse conditions would have been to try to get our users coming into Europeana to make sense of very different ways of expressing the extent to which content can be reused. So the solution for this aggregation context of Europeana was found in using a set of standards that all of the institutions providing data need to rely on to communicate in an easy way the extent to which the digital cultural heritage can be reused. So what you see on the screen is an item page. So if you go into Europeana and click on an item, you will see the digital representation followed by the metadata. And just at the top of the metadata, you see like a little sign, in this case, CC BY, which indicates that this material can be used as long as attribution is respected. If a user is not familiar with this tool, they can click on the little button and they are taken to the Creative Commons pages maintained where they explain the conditions that this license is subject to. Whoops, and now okay, sorry. I put the link and now I'm taking you to the item page. Just before I explain which are the actual tools that we work with, I just wanted to highlight a couple of benefits of using standardized rights information. So first of all, what I was saying, it provides a lot of clarity for users. So on Europeana, we can rely on these standards, which are very easy to understand, instead of having to have very long descriptions of reuse conditions that would be subject to different jurisdictions, written in different languages. So for us, guaranteeing that the reuse conditions are understandable is the way to foster reuse. Another important aspect of these various standardized tools is that they can be understood worldwide because they are translated to multiple languages, especially Creative Commons licenses and tools. Not only the words, but also the legal terms. So there have been lawyers checking that the licenses and the tools make sense across borders. They are also machine and human readable. So other than seeing the license deed that you were just seeing in the previous slide, they can also be identified through machine readability means. And that's not really so that's not really a characteristic of the licenses and the tools and right statements. But it's important to remember, just in case there's a doubt, that they are tools that are free and available to use by any cultural heritage institution who is interested in using this type of resource. These standards, the ones that I'll be talking about in more detail in a second, are maintained by various institutions. So Creative Commons licenses and tools are maintained by Creative Commons with the headquarters in the US, and a large network of creators, cultural heritage professionals, etc. You've got also Connor, and I think I saw Brigitte coming in. So if you've got any questions about the legal structure behind the tools, you can also ask them. And then rights statements are maintained by a consortium that was created a couple of years ago called the Rights Statements Consortium. This consortium was initiated through a collaboration between Europeana and the Digital Public Library of America, who were kind of facing the same problem, or like the same need of wanting to express reuse conditions in a very understandable way. Then they were joined by a number of additional aggregators that work nationally or regionally. At the moment, we're rethinking the structure of the consortium to make sure that it has a sustainable future, to maintain the funding and the involvement of the people who use the statements. So we're in a sort of a transition phase. But I can just guarantee that the statements are still available for use and they are maintained. They were hosted by kindly hosted by the National Library of Luxembourg up until now, and now we're transitioning to the hosting being held by Europeana. So the statements will continue to exist, and we're looking at how to ensure the sustainability of the organization behind the right statements. So I wanted to tell you then about the actual tools that we use at Europeana. So that is the actual licenses, tools, and right statements that any organization providing data to Europeana can choose from and assign to every digital object. There might be other tools, like for example, the traditional knowledge labels, but we don't work with all of them. The ones we've chosen to work with are the ones you see on the screen, with the exception of the 6 right statements that you see at the very right-hand side, because when we were, my former colleagues were organizing this, they kind of judged that some of the ones on the right were not necessarily suitable for our activities. For example, I can talk about this later if it's interesting for any of you. But anyway, so when an institution wants to provide data to Europeana, they have to assign one of these tools to every digital object. So they can choose from one of the 6 Creative Commons licenses, one of the 2 Creative Commons tools, or 6 out of the 12 right statements. The idea is that And that's really important to remember, that Creative Commons licenses are only applied by the cultural heritage institution if the institution holds the copyright, or with very clear permission from whomever holds the copyright. Because Creative Commons licenses are a legally binding tool, which basically say, I, the rights holder, allow you, the general public, to use this material under certain conditions or with certain limitations. So it's very important that this decision is made by whomever holds the rights. We can speak about how the characteristics of each of them later on if you're interested. The public domain tools, there's the public domain dedication, which should also be applied by the rights holder, and a public domain mark, which is an acknowledgement that the material is in the public domain. And then on the other hand, rights statements have a different nature. They are not licensed, they are not a legally binding tool. They are basically an explanation of an assessment that the cultural heritage institution that has the material has made. So, and instead of explaining in very lengthy, complicated words, it's explained through a standard. So that means that even if the institution does not hold the rights, the institution can still apply these labels in order to communicate what they know about the rights. So the idea was that rights statements, actually in the context of Europeana, we always encourage data providers to use, if possible and if it's correct, to use Creative Commons licenses and Creative Commons public domain tools, because these are the tools that really enable opening up and enable the reuse, well, more reuse than most of the rights statements. Only when applying this is not correct, then we recommend looking at the various rights statements available and choosing one that fits the specific circumstances. So for example, the first right statement in copyright basically says, I, the Cultural Heritage Institution, inform you that this material is still subject to copyright protection. And we assume that the institution does not have any more rights to authorize further reuse. The second one means no copyright, but there are other legal restrictions that the institution is aware of and wants to inform the users of. Etc. We can also talk about them in more detail if you're interested. And maybe just the last thing that is important to remember is that they're not supposed to be applied in combination. So the idea is that one item has one right statement. I've heard some people say, how about we apply the in copyright right statement and then CC BY as a way to say it's in copyright and we want to enable you to use it in any way as long as you attribute. That's not necessary, and maybe probably the license date and description wouldn't be entirely compatible because that's not how they were meant to be used. And in any case, all of the CC licenses imply that the material is in copyright, so it wouldn't be necessary to add an right statement to make that precision. And so the last thing I wanted to share is that once you see these various choices and are thinking about which one to apply to a specific item, it's not like you can choose from amongst all of them to attribute it, like to assign it to a specific item. There will be choices that will be incorrect and choices that will be correct, and then choices, well, you will have various choices, and then it's up to your institution's own policy on how to make the choice that is the most, well, the one that reflects the most institutional policy. So in order to choose a correct right statement, a correct tool, or a correct license, there's a couple of things that we want our data providers, so cultural heritage institutions, to consider. The most important one is to try to make the determination of whether the item is subject to copyright protection or not. If it is subject to copyright protection, Creative Commons licenses and some right statements will be suitable. If it's not subject to copyright protection, then the public domain mark and the no copyright right statements will be the ones that should be used. The second thing to consider is if the material is in copyright, then it's very important to have clarity on who the rights owner is. If the Cultural Heritage Institution owns all of the copyright, then it has the freedom to apply a Creative Commons license and to choose which one to apply. But if the rights owner is someone else, the Cultural Heritage Institution should not be applying anything that has legally binding conditions. Another thing to note is that at least from European and many other organizations, we really encourage you not to claim any rights on digitization. That's only possible right now if the digitization is really a work of art in itself, it's original in itself, but that happens very rarely. And even then, we would still encourage you not to claim this double layer of rights. So when choosing a right statement, we believe it's very important to choose it on the basis of the underlying material. If the underlying material is in the public domain, pick a right statement or or the public domain mark that indicates that it's in the public domain, and do not add an additional layer of rights by claiming rights on the digitization. The other thing that is important to note is that these tools are mostly based on copyright, but there are some options that express additional types of conditions or restrictions, like the no copyright, but other no legal restrictions. So if you, as a cultural heritage institution, know that these restrictions exist, you might want to use that right statement. And then in the metadata, maybe include additional information about what these restrictions look like so that the user can make its own assessment about the extent to which the material can be reused. And the very last thing is that if you have, maybe let's say you hold all of the copyright in the material as a cultural heritage institution, which doesn't happen that often. But if you did, then the choice, for example, amongst all of the Creative Commons licenses will be in line with the extent to which your organization is willing to enable reuse. That is willing to enable, is willing to open up the material. So these are various parameters to consider when choosing the right statement to make sure that you're choosing the most accurate one. Sometimes I use right statement as encompassing all of the different tools, but well, that's what I meant in this context at least. And I think I'll leave it at that, and we can pick up questions later on, I think. Thank you.
Okay. Thank you, Arianna. So we are an institution for the Art in Flanders platform. We decided to review our labels in function of all the parameters Arianna just talked about, and I'll just quickly walk you through that. I just need to be able to share my screen.
That works.
Okay, perfect. Thank you. So we kicked off a project where we wanted to update or review the rights labeling policy for this platform we host at our institution, which is Art in Flanders, and where we have digital copies of artworks of museums all over Flanders that we propose to the public. And actually, the main incentive to start this review was that we noticed a few inconsistencies in the situation. So here you see on the right, so it's a reproduction of a painting. On the right, it says license CC0. On the bottom, it has a photo credit, and it also mentions the name of the photographer. But actually, this work is old enough to be in the public domain. It's by Leon Spiliart. He died in, I think, 46. So there's too much rights information that is inconsistent. This is not really useful for the end user. What is this now? So the idea was, okay, because I cannot see my own slides here. So the idea was, okay, we want to review and update this labeling policies to have clear, up-to-date labels that are useful for the user. So, so first what we did is we formulated a few guiding principles. In fact, we have two of them. The first one is we wanted to be as open as open. So as Arianna just explained, we wanted to avoid having these surrogate copyrights over public domain works through digitization. This is in line with what we saw in the Article 14 DSM directive, and this is also something that was already moving along through Europeana and the other public domain lobby initiatives. The idea was what is in the public domain stays in the public domain. But on the other hand, we also wanted to be as close as necessary, because there are still copyright or other legal agreements that can be applicable and which we need to honor. So there is the issue of copyrights of the photographer in the case of 3D image, 3D objects reproductions, because for 2D images, we're quite sure they won't have the threshold of originality, so no copyright for the photographer. But there is unclarity regarding the 3D reproductions of 3D images, objects, because there the photographer makes his own decisions regarding viewpoint, lighting, etc. So as an organization, we decided that we didn't want to go as far as to say that, okay, for all artworks, we waive all copyright protection on digitization. So we make a distinction between 2D and 3D. Another very important thing for us, because we don't actually have the physical collections. The objects are in collections of museums, and they give us the physical objects, or they give us the access to digitize the objects. And so what happens is that some of the content providers will say, okay, you can come digitize this altar in our church, for instance, but only on condition of, etc., etc. So they impose user restrictions based on the fact that they own the physical objects. This is difficult for us. We're not so sure how robust this is as a legal basis, but there is also something else that is important for us, that is the relation with these content providers. So we really need to respect these rules. So we have for the public domain works, we have 3 main cases for which we proposed new labels. The first one is is the simplest case, where we have a painting, so a 2D artwork that is in the public domain, so no copyright applies. Also on the level of the photo, it's a technical reproduction, so no copyright applies. The old label was CC0, but CC0 is a copyright waiver, which implies there's still a copyright. So the proposed new label was public domain mark, which says there's no copyright at stake here. The second case, I don't know. Yeah, so the second case is the case where the collection owner imposes restrictions. And what we actually used to do is translate these restrictions into Creative Commons licenses. So this one, for instance, comes from a collection owner that's a church. And as restrictions, they say, okay, we don't want the reproductions to be used in disreputable context. We need to vet all reuse, etc. So we used to translate this in the most restrictive Creative Commons license we had. But of course, it's a public domain work, 2D. So no copyright there. Also, the photo does not give rise to copyright, so this is really not the way to go. This is not a bad practice. So what we proposed here is a right statement, because there's no copyright involved. The right statement saying no copyright involved, but there are contractual restrictions. And then the third case is the case of a 3D art object that is in the public domain. So the work is in the public domain, but we're not so sure whether the photo is. So as opposed to what Ariane was saying, that is always a right statement of the underlying artwork. For us, we rather see this as it's a sum of all the rights that can play. So what we decided here is that the label, we had the label CC0, but we saw in the contracts actually that this was too liberal, because the contracts always said required attribution of the photographer. So what we wanted is we wanted to keep it CC0, because then in practice between CC2D artworks and 3D artworks, there's no difference between CC0 and PDM. We didn't want to have a CC BY on a public domain work, obviously. So what we did, so we wanted to keep the CC0, and what we did is we went back to the photographers and asked them to change the contracts. So the things that we did first, well, we asked a legal advice on this. We reviewed the IP clauses. We went back to the photographers concerned, and this sounds like an easy step, but it was actually a quite difficult one. Also on the technical functionalities, what we wanted to have is one label for the public, that is the sum of all the rights that a user needs to take into account. But back office, we wanted to have this layered registration. So there's a complexity also there. And front office, we were thinking like, okay, we don't want to impose legally name attribution of the photographer, but we could request this as a good practice. We could also request attribution of the holding institution, of the content partner, and this is something Connor will tell more of. So this is what we also needed to have all the content partners on board, which also looks like an easy step, but it's not as easy as it sounds. So for now, this is where we have a conceptual framework, and we are now taking the steps to implement it in practice.
Yes, that's a very good transition. I'm just going to share my screen and see if this works. Can you see this okay? Yeah, great. Yeah, so what I would like to talk to you guys about is some new guidelines that we've created at Creative Commons, which we call nudging users to reference institutions when using public domain material. So my name is Connor Benedict, as has been mentioned. I work for Creative Commons. And just to give you a bit of context on the Open Culture Program, we work on these 4 areas, so policy, infrastructure, capacity building, and community engagement. That basically means that we work on national and international policy work. We have our licenses and legal tools, which many of you are probably familiar with. We provide trainings and webinars, like participating in this. And on the community level, we have the Open Culture Platform, which many of you are part of, among other things. To give you some background on these new guidelines, in 2022, an Open Culture Platform working group, which Ellen was a part of, investigated the use of CC licenses with public domain material online, and they developed a number of recommended solutions to address the widespread but ill-advised practice of applying CC licenses to public domain materials. The new guidelines that we published follow the social intervention recommended from their report, which I'll get into a bit in a second. Creative Commons recommends against using CC licenses with public domain material, specifically because it creates a lot of uncertainty as to the copyright status of the material. It can be misleading and create confusion for users as to the access and use conditions of the material, which is something Ellen also pointed to. It can create situations where licenses are invalid or ineffective and unenforceable. And lastly, it does not necessarily lead to the mention of the institution or the attribution of when the material gets reused on other places. So what we proposed is, or what we recommend, is that institutions create a reference statement that kind of encompasses the most important aspects, which are the title, the author or the creator, creator, copyright license or permissions, the institution, and the source. So this is kind of +1 to the standard TASL, which is title, author, source, and license, to include the institution, and to provide that kind of with the material in an elegant way. The guidelines also move towards this idea of nudging. So how do you nudge a user, not just to receive the information, but actually make the effort to reference the institution and where it comes from? So what we say is, based on Behavioral Insights Team East model, to first of all, make it easy for users to reference, make it attractive, so something that they want to do, make it social, so connected to others and social value and kind of the broader impact of why it's important, and make it timely, so consider when you provide the information and how it's presented in the right moment. We have in the guidelines as well, basically a handful of design suggestions, but I'll get into a few technical suggestions as well. The first design suggestion is essentially to put a button next to a reference statement. So not only provide the information, but make it easy for people to grab it. So put a copy button next to the reference statement so that they can easily put that information where they might be resharing it. Another example is that when an image or an item gets downloaded, that it automatically gets downloaded with a text file that has the reference statement included. A pop-up that also presents the reference information. This one is probably you are familiar with from Europeana's framework, but just augmented a bit with a copy button so that it's clear what you can do with it, or maybe even add an email button so you can send it to yourself. And lastly, this one's a bit more of a technical lift for an institution, but maybe something Europeana could explore, essentially having user profiles. So if you're a frequent user of a platform where you get a lot of your resources, you can consider having a user profile that keeps track of the things that you download, so you can always go back to it and see the reference statements and use them in your work going forward. So for all of this to work, it's important that you organize your data. So within a CMS or a DAM system, you have at least 2 ways to implement this, or we recommend 2 ways. One is to write the reference statement out. So as I said, you include all those different information bits into a reference statement, or you create a structure so that the metadata tags correspond to a reference statement. So you have a metadata item for title, you have a metadata item for the institution, and that those components essentially build a reference statement that gets used. So it's really important that you consider how your metadata is structured and how it's associated with the item, so that you can create a reference statement that's useful for people, but also to communicate things in a good way. I'm sure you guys have some questions, so thank you for giving me a minute to talk about this, and looking forward to the discussion.